So welcome everybody. Thank you so much for joining. My name's Nick Graham and I'm going to be chairing this afternoon's session. This is the Denton's Global webinar on COVID, a new normal. And really, I think we're there already. I had a trip to the supermarket the other day and I had hand sanitizer available on the way in, one-way walking systems in the store, Perspex screens, latex gloves. And the World Health Organization has said, interestingly, and maybe this is not a surprise, that we may have to live with this virus for up to 5 years. So this is raising all kinds of privacy issues, and we're going to touch on those in this session. First, I'm going to share some thoughts on some of the trends that we're seeing in the market based on our research. And then I'm going to introduce a number of people who I think you can probably see already, but I'll introduce them properly. They are going to split into 2 panels for discussion. Here are our speakers. And in the first panel, we're going to look at the release from lockdown, things like thermal cameras, temperature checks, and the like. In the second panel, we're going to focus on apps. Apps is getting a huge amount of publicity. It's a major area of interest and concern. And so we're going to touch on that too. Hopefully, we will have time for some Q&A at the end. So as this is a Zoom call, you'll see at the bottom of your screen a Q&A icon. So if you have a question towards the end of the session, we'll do our best to address those. We are recording this session so we can share it afterwards. And so let's flip to the next slide. So the point here that I wanted to get across is the Economist Journal has coined this phrase, the 90% economy. And it's getting really at the fact that when we get back to work and when the economy gets going again, it may be different, because people will be less comfortable being in busy places like shops, restaurants, bars, perhaps open plan workplaces. So does it make us more fragile as an economy? Is it less innovative? It probably has an impact in terms of income distribution between different demographics and different geographies. Then the next slide is some data that we've got from Fitch, which is a ratings agency. So what we've tried to do here is identify by reference to the ratings stats, the impact in different sectors. So red is bad, pretty obviously, and at the top of the diagram you can see, and maybe this isn't a surprise, areas like leisure, transport, banking, retailing, all being significantly affected. Transport in particular, obviously. Go down to the bottom of this slide and you'll see less affected areas. I mean, still affected, but less so. So technology, natural resources, food, beverage, tobacco. And so we just thought that was a sort of interesting perspective, and it kind of reflected our view of what we're seeing in the market in terms of how it's impacting client organizations. On the next slide, we've got some stats on internet usage. We're all at home, we're doing video calls like this one. So this is going to have a significant impact on traffic, and you can see the increase in traffic on the networks has been quite marked. So Italy, for example, 109%, Spain 39%, the US is up there in the 30s and 40s, and also with a negative impact on download speed. So again, just interesting to see a facet of this kind of new normal in which we find ourselves. Then on the next slide, we flip to the output from some research we've done. I take this as a kind of work in progress, but what we've done here is identify the countries which are either launching, have launched, or are developing COVID contact tracing apps. And we're going to hear from a number of our global team during this session on issues in connection with those apps that you can see straight away this is very much a global issue. And the last, and raising common issues, as we'll see, in common themes. You might also ask, well, what's my office going to look like in the future? Well, this is a little more aspirational, but here's a artist's impression of an office of the future: touchless technology, antibacterial surfaces, lots of space. Is this real? Well, all of us, I think, on the call will know this is a long way from our current office environment. So if this were to become anything like reality, it would be a very significant change from what we're used to. So let's go to the first panel, and I'm going to introduce each of our panelists and then ask all of those panelists a question. And the first person that we're going to hear from is Giangi Olivi. Giangi heads our practice in Milan, Italy, at the epicenter of this in many ways. Then we'll go to Chantal Bernier. Chantal is based in Ottawa in Canada. She's the former Privacy Commissioner for Canada. Then we'll hear from Juanita Acosta, who's based in Bogota, Colombia, and we'll be speaking about Latin America. And then Shahid Suleiman, who's based in Cape Town, South Africa. So my question is, we're seeing big developments in terms of release from lockdown. What are the privacy risks that you're seeing in your jurisdiction, and how are those being managed in practical terms? So if I can go to Jianji first.
Yeah, thanks a lot. Thank you for this brilliant introduction, Nick. What I would say, we are in the phase of, in the so-called phase 2. So we are trying to go back to normal in Italy. And from a data privacy perspective, we are following the path that had already been devised by the European Data Protection Board. And basically, the European Data Protection Board set the scene in March with 2 statements where it said, well, no panic, because the GDPR is flexible. We do have a broad legislation that allows for employers and competent public authorities to health authorities to process personal data, also without the need to obtain the consent on the data subjects. So and in this respect, the European Data Protection Board also set the scenes with regard to other activities that might be, for instance, geolocalization and tracing through apps. And as for geolocalization, it excluded the possibility for geolocalization, and it also set the scene stating that the tracking apps should not be compulsory, which led some debate that might not be a good application of Article 52 of the European Charter of Fundamental Rights, whereby any limitation of the exercise of the rights and freedom should be provided by law and subject to the principle of proportionality, and these objective assessments should be made more than by the governments rather than by the European Data Protection Board. So this is still an open debate. But that said, to answer your question, where we are in terms of risks, I'm not talking about tracing apps because we're talking about them later. There's no widespread usage of tracking devices, but there is a large use of temperature checking. It is not compulsory in Italy. It is compulsory, the temperature checks to employees only in the region of Lombardy so far, considering that the Lombardy is the most affected region, but it is highly advisable. And in some instances, the automatic form of temperature checks are considered a bit too privacy invasive. So there's still traditional temperature checks, and the temperature should not be registered. But what should be registered is the fact that the criteria has not been met to allow the employees to enter the premises. So this is obviously the main risk being taken into account is the risk of spreading the epidemic within the office. So it's most controls within the office, and there are some clear guidelines provided by in various European jurisdictions, including Italy, but the European Data Protection Authorities, setting the scene on where you can enter certain premises through having to go through temperature checks or not, whether these are customary or not, and what to do with the relevant data. So if you want, we can then further expand on this point.
Okay, well, actually, let's thanks. So it is, and we're getting this impression it's actually quite fragmented in terms of mandatory versus voluntary on temperature checking, for example. Let me go to Canada, because I think there's an interesting perspective, Chantal, isn't there, in how Canada has responded to this?
Yes, thank you, Nick. So really, the privacy issues have crystallized around 2 main risks. The issue of government contact tracing apps and the challenge of employers to, on the one hand, honor their obligations on occupational health and safety laws, and on the other hand, respect the privacy of their employees. And I will address both in sequence. So in relation to contact tracing apps, the government of Alberta was the first out the gate, adopting an app that I believe you will find similar to what Australia did, and Robin will describe soon. Voluntary, minimal personal information collection, meaning cell phone number, with a also strictly defined purpose of exclusively public health protection, and it is already planned to be decommissioned when the pandemic is over. The Information Privacy Commissioner of Alberta has responded, saying that she wants to fully review the privacy impact assessment and that she wants the Alberta government to be transparent in adopting of the app and using it, as well as make sure it is proportionate. And sure enough, if you go on abtracetogether.ca, you will find a web page exclusively on the Alberta app by the Alberta government with a video that makes it very clear as to what is collected. The Information and Privacy Commissioners of Canada, including the Privacy Commissioner of Canada, have issued a joint statement on contact tracing apps, and they continue to insist that it must be voluntary, it must be science-based, meaning exclusively targeted to what science commands in terms of public health surveillance, which is where I would like to make an asterisk, saying that if facts changed and the app were to become scientifically necessary to contain contagion, well, there would be flexibility within the Canadian legal framework to accept a mandatory app. But we are not there yet. And that is why, at this point, the Privacy Commissioners have made it clear it must be voluntary. Moving then to employers, we see, of course, a need, as Janji just described, to protect employees within the workplace. And what employers, we feel, must understand is, first of all, that it is a case-by-case analysis. There are workplaces where the issues of public health are so acute that a much more invasive form of surveillance, including testing for a temperature, including questionnaire, including biometric data, will be warranted, while others will not allow it because it is not factually justified. We also encourage employers to duly document their due diligence in choosing one method or another. We encourage also the employers to engage the employees, inform them, notify them, and of course get consent unless there are exceptions such as necessity so prevailing that the measure will be obligatory, but then the employee can go home if he or she refuses. And then there are mandatory disclosures, such as where it is in the best interest of the individual and consent cannot be obtained, or where there has to be disclosure to public health authorities under public health legislation, or where there's a reason to believe that the employee has violated, let's say, a quarantine order. We also recommend that the employers make sure that whatever they adopt have functionalities that allows proportionality in implementation. And finally, we would also say that employers should review their breach response plans to make sure that they have incorporated this new variable, which is telework, in terms of removing devices from premises, in terms, of course, of using platforms, as your diagram has shown, as well as, archaic as it may sound, as removing paper from the office. But the fact is that we are in a new environment for work and protecting data, and therefore breach response plans and safeguards should be reviewed accordingly.
Excellent. Chantal, thanks so much. And so now we've heard from Italy and part of North America, let's go down to Latin America. Juanita, you're based in Bogota, Colombia, but you've got a good sense of what's happening across Latin America. Can you talk a little bit about where Colombia and neighboring jurisdictions are in terms of privacy?
Sure, Nick. Thank you. Thank you, and hello, everybody. Yes, first of all, I would like to give you a snapshot on the situation in Colombia and the most relevant Latin American countries, and then discuss the main privacy conversations that we are having in the region. In Colombia, we have a 50 million population, which makes us the third country with the highest number of inhabitants, following Brazil and Mexico. Currently in Colombia, we have 22,000 confirmed cases and 750 deaths. In Latin America, most of the countries have taken serious lockdown measures to control the pandemic, including Peru, Chile, and Ecuador, which are being seriously affected by the illness. Brazil and Mexico, which have also very high numbers, have adopted more relaxed lockdown and prevention measures. Media has recently pointed out that the region is the next silent epicenter of the pandemic. As from the Colombian perspective, the Brazilian and the Venezuelan border pose concern for the health authorities in my country. The Colombian border with Brazil is very unique because we share the Amazon River and the Amazon rainforest as a natural border. So it has become a vector of entrance of the disease from Brazil into Colombia due to the floating population that we have in that area. The Venezuelan border, on the other hand, is handling a pendular population because people are now trying to return to their homeland from which they fled in the last couple of years, seeking for better opportunities than the ones granted by the Venezuelan government. Colombia has undertaken serious and responsible approach towards the virus, considering, of course, the challenges of our economy as an emerging economy. We have been in lockdown since March and are now seeing a controlled restart of the economy. From the privacy perspective, I can highlight that Colombia, as most of the Latin American countries, has taken an approach of data privacy as a fundamental constitutional right. The local Colombian Data Protection Authority has highlighted that even under the current situation where consent may not be required due to the fact that we are facing public health issues, the principles of data treatment must be strictly respected at all times. Our principles, for your information, mainly reflect those included in the GDPR. The main topic of conversations locally regarding privacy issues refer to tracking app issues, compulsory temperature checks, and the role of the employer when handling high amount of sensitive amount of data. Regarding the tracking apps, we have had interesting conversations during the last weeks since the government and some cities have launched voluntary tracking apps. The terms and conditions of both the governmental and the local apps are very basic and generally mix the privacy policy and the terms and conditions of use without them having clarity of the purposes of the data treatment. Certain nonprofit organizations and media have reported that the government is analyzing whether they will be migrating from the tracking app that we have now to a decentralized model that Todd will further explain following the Google Apple model. Different stakeholders have commented that the apps that we have now requires them feeding them with unnecessary information and the fact that they do not offer sufficient information. Despite the fact that these apps are voluntary, protocols from the government and localities request employers to encourage the use of them by their employees. As some employers have requested employees to download the app as a requirement to return to work, the particular issue has been elevated through a constitutional action of a particular employee for a court of Medellin, which is the second city in Colombia to review. Last Friday, the court in Medellin decided the constitutional action and considered that the health and privacy rights should be balanced, that the employees' rights were being affected, and compelled the authorities to maintain and respect the privacy principles regarding information purposes and to process only the minimum data required to fulfill the necessity principle. We do also have compulsory temperature checks in which the companies must check the temperature of the employees, guests, and vendors. Little information has been, or guidance have been given on that. And if you want, I can further expand on that, but I think that I met my 5-minute.
Juanita, on that Medellin court decision, did that mean that they could use the app, but with limited data, or not?
They could use the app, but with limited data, only to fulfill the necessity principle.
Yes. I mean, I think that's an interesting angle that we haven't heard much debate on, actually, which is the point Jianji was making at the start as to whether these apps should be voluntary or mandatory. A lot of the discussion in my experience, or from what I've read, is more around how it works, centralized versus decentralized. And we're going to get onto that in the second panel. Juanita, thanks so much. Okay, so a little break for a second. We're going to, on Zoom, we have this functionality to do a poll. So on your screen in just a second, there we go. We'd like you, please be assured this is completely anonymous. As you can see, we're not collecting any data here. Are you seeing temperature checks being carried out in your country? If you could all vote now, it would just be really interesting to get a sense of how commonplace this is, because I think we think it is, but we just wanted to test that with you. So are you seeing temp checks being carried out in your country? Clearly, most of the people on this call will be work from home, but for those key workers and people going to factories and so on, are they being temperature checked as it is? So we'll come back and have a look at the result in a second. Let me come to Shahid Suleiman. Shahid's based in Cape Town, South Africa. Shahid, same question to you. What are the privacy risks from your perspective, and how are you seeing them being managed?
It helps to unmute yourself before you start. Thanks, Nick.
Thank you.
We've been in lockdown since 27th of March. At the end of April, the lockdown released partially, and we're expecting a further release to take place on 1 June. At the time that the lockdown was initiated, the infection rates were increasing exponentially. Shortly after the lockdown commenced, the infection rates dropped very, very materially. As time progressed, the infection rates are again starting to increase. At the moment, we're seeing something between 500 to 1,500 infections a day, with the death rate in the region of tens per day. There seems to be a general consensus that the strict lockdown has passed its sell-by date, and there's immense pressure on government to relax the lockdown very, very significantly. Those who have been following the news will know that there have been some very strange stances taken by the government. So, for example, the sale of T-shirts has been prohibited for a while, as has been the sale of open-toed shoes. Interestingly, tobacco and alcohol has also been prohibited. The sale thereof has been prohibited, not the consumption. And on Monday, we expect that the sale of alcohol will be permitted, whilst the prohibition on the sale of tobacco continues without there being any clarity as to when it would be permitted again. We see some of this confusion as well in the manner that privacy issues have been dealt with. In the first version of the regulations that were issued, provision was made for a tracking database to be maintained by the state. And amongst the rights given to the state was to require telecommunications companies to provide the state with movement and location data for any person who had COVID-19, was suspected of having it, and any person who had been in contact with such a person or was suspected of having been in contact with such a person. There were no limits on the collection of that data, the storage of that data, and the utilization of that data. As you can imagine, there was quite a lot of uproar in respect thereof, and the next iteration of the regulations addressed many of the concerns that had been raised, but we'll come to that in a bit more detail shortly. So the disaster management regulations which govern the lockdown are pretty draconian. They have been lightened over time as the country has passed through the different levels of the state of disaster. With regard to the workplace, there is an anticipation that there will be a significant return to work on Monday with the dropping down of the state of emergency, or state of disaster rather, from level 4 to level 3. Amongst the requirements in the workplace is that the employer must put in place a workplace plan. The workplace plan must deal with the typical issues, I think, which you've seen in many other jurisdictions, such as screening arrangements, such as specific arrangements for vulnerable persons, and the like. I referred earlier to the contact tracing database, and I mentioned that initially the powers granted to the state were very broad, and that these powers were then circumscribed subsequently, make them more consistent with privacy laws. Before I give you details about that, perhaps a very brief update on the status of the privacy legislation in South Africa. There is in force legislation that corresponds in large measure to the European legislation. However, that legislation is not yet fully in force. The substantive provisions of the legislation were expected to come into force on 2 April. With the commencement of the lockdown, that did not materialize. There are currently rumors that it might come into force in June. I would not hold my breath for that personally. I suspect it's not going to happen in June, but let's watch that space and see what happens. Currently, what that means is that privacy in South Africa is governed by the constitutional right to privacy, and secondly, by the common law principles regulating privacy in South Africa. There are no detailed requirements or guidelines in force at this stage, pending the substantive provisions of the privacy legislation coming into force. If we go back to the contact tracing database, we find that, first of all, there's an obligation on accommodation establishments to report to the state those who are making use of their services. That having been said, the right of accommodation establishments to conduct business has been very severely curtailed during the lockdown period. Secondly, as indicated earlier, the state is entitled to request location and movement information from telecommunications companies, whereas that right was an absolute or relatively absolute right in the first iteration of the regulations. The right now is circumscribed in a manner that takes into account many of the data protection principles that are covered in the privacy legislation, which is not yet in force. So, for example, there is a time period limitation during which the data may be collected. Secondly, the data must be destroyed after 6 weeks. After the state of disaster, the government is required to give notice to every person whose data had been collected from the various telecommunications companies. So given the broad power that the state has, one might wonder what is the use of a tracking app in South Africa. From a state perspective, there's no real need, I think, for a tracking app. The state could simply issue directives to the various telecommunications companies and request that they deliver up to the state the relevant information concerning infected persons or persons who came into contact with them. I suppose a tracking app would be useful for individuals, since it might give them information concerning their own movements and the extent to which they might have come in contact with persons who have been infected. Nick, I think I've reached the end of my time allocation, so I'll hand it back to you.
And Shahid, that's really interesting. So you're kind of, you don't have an app. I know one's in development, but you're kind of there already in terms of the data being, in theory at least, accessible to the government. So in some ways more intrusive, as we can see from some of the other jurisdictions. And I actually, that's interesting what you say about the privacy law, because it's been talked about for a while in South Africa, going back, I think, to the Soccer World Cup when it was due to be brought in. And there's been a sort of, I know there's been a sort of a series of delays. I have to ask, maybe later if we have time, as to why you want to ban the sale of T-shirts. I'm intrigued with that, but time's against us on that one. So I'm going to move on. Thank you, Shahid. Actually, just before we do the second panel, I think we can hopefully get the poll results. So the question was, are you seeing temperature checks being used? And the answers are yes, 58%, no, 42%. And I guess that's a transitional thing. So I would expect the yes to increase over the next few months as more of the economies restart and as more of us go back to work. But it's debatable because it's only, as one of the key themes I think in this area is there's no single silver bullet. I'm sorry, I know that's a cliche, but none of these tools are going to be used on their own, but this is certainly a key one. So let me come to the second panel, and here we really want to focus on technology and apps. Lots and lots of discussion on this. I want to start with a North American perspective. Todd Daubert, based in DC. Can you talk to us a bit about what's the US perspective on apps in terms of contact tracing?
Yes, thank you very much, Nick. I think that one of the most interesting things about the apps, what we're seeing around the world, is that the approach to apps in specific countries really reflects our philosophy towards privacy and our forms of government. Because as you know, in some regions, privacy is a fundamental human right, whereas in other regions, including the US, it's not a fundamental human right, but it's centered more around, our rights have grown out of basically the Fourth Amendment and protecting people's reasonable expectations against government intrusion. So we have a patchwork of laws that are really, most of which are based on this idea of notice consent. And we also have a democracy, of course, where many of the issues are regulated at the state level and not the federal level. So when it comes to the apps, the default at the moment is private control with regulation at the state level. And this leads to strengths and weaknesses when it comes to these issues, like COVID-19 tracing. And I think that when you consider what's going on, there are many apps out there already in the US, since there's no comprehensive privacy legislation like GDPR or other things to govern what happens. So you've got apps that are using GPS location, you've got several. The most important movement that's happening right now is cooperation between Apple and Google. And this is so important because Apple and Google, their operating systems control such a majority of the devices in the US, and they reflect the power that private companies have in the US over these types of issues. You may recall that in the US, there have been a lot of pressure from the government on Apple, for example, for creating backdoors or for allowing the government to have access to phones of terrorists. And Apple has said no. And so when it comes to the app initiatives that Apple and Google have teamed up on, their private control is really important. And I think it can be a strength if you trust the companies as much or more than you do the government. So what's really important is by teaming up, they can make sure that their systems can talk to each other and that they have consistent forms of operating so that your adoption rate essentially is much higher. So here's how it works. So it requires users to turn on a Bluetooth beacon and to enable the functionality. So step one, without a user choice, nothing happens. Once that's turned on, it transmits a random Bluetooth identifier. It is a completely random string of numbers. It's not tied to individuals or devices. And it actually changes every 10 to 15 minutes. So when another phone who has also turned on the functionality receives this beacon, they record the beacon on their own device. And then at least once per day, the system downloads a list of keys for the beacons that have tested positive. And again, you have to alert the system that you've tested positive. And then when you've alerted, then it sends a notice to the people who have relevant keys. And so if you don't upload that you've tested positive, nothing will happen. And so it's essentially a notification app. So there are two phases to it. For the first phase, which has already been released, it's an application programming interface. So it's a common API, and it's implemented through each company's developer program. So you have to go in and you have to agree to additional terms. Focusing on Apple for a second, Apple vets who gets access, and they allow only public health authorities or developers who are endorsed by the authorities. And at this stage, it requires apps to be created and to be downloaded by individuals, and then the apps get information from the API. So that's the first phase. They're working on the second phase, which is supposed to be released in about a month or so, that all of these functionalities are going to be built into the operating system itself. So you don't need to download an app to do it, and it should work more effectively. Users still have to opt in. So the privacy protections that are built in, there's no collection of location data, no sharing of identities. Users control all data they want to share and the decision to share. The Bluetooth identities are changed every 10 to 20 minutes. Exposure notification is only done on the device and under the user's control. Systems only available to public health authorities. And Google and Apple have committed to disabling the system on a regional basis when it's no longer needed. The privacy concerns that you're really seeing come up is that will government and private sector restrict access to spaces and opportunities based on whether you have consented? For example, will employers start to say, if you haven't consented to the app, you don't get to come to the workplace, or you might not even get a job? And you know, this is a very common issue in the US. For example, US employer email. If you don't provide your consent to use their email system, you won't get access. And so that raises very serious questions about whether the consent is actually valid under these circumstances. And there's calls for federal law on this. And so right now there are two bills pending. One is a Senate Republican bill called the COVID-19 Consumer Data Protection Act, led by 5 Republican senators, led by Roger Wicker, Republican from Mississippi. And then there's a Senate Democratic bill, well, Senate and House Democratic bill called the Public Health Emergency Privacy Act, led by Richard Blumenthal, a Democrat from Connecticut, and Mark Warner, a Democrat from Virginia. These two bills have a lot in common. They require data minimization, data security, transparency, an exit strategy, and enforcement mechanisms. For example, state AGs and the FTC would be able to enforce. And they require mandated deletion to sort of keep away from this surveillance inertia. But the big problem is there are two areas of fundamental disagreement. First, the Democratic bill provides for a private right of action, which means lawsuits for violation of the bill. It's a very serious issue in the US and has created a lot of conflict whether that should be allowed. And the second is whether state law should be preempted. And the Democratic bill wants to preempt state law. So there's a serious question with respect to whether anything's going to happen, because these are the same two areas of dispute that have prevented federal privacy law from being enacted. I'm out of time. I would love to continue, but in respect for my panelists, I'm going to cede the floor.
And with that, thank you, Todd. I'll come straight to Simon Elliott, based in the UK. Simon.
Thanks, Nick, and hi, everyone. So I think just to give a context to the UK position, I think it's fair to say at the minute we're in the middle of a slightly muddled release from lockdown. We have unfortunately had, I think we're approximately 37,000 deaths due to COVID in the UK, which is a bit of a real national tragedy. But we are in a position now where from early next month we will see more children return to school, and from the middle of next month we're due to have non-essential retail opening subject to social distancing measures being put in place. I think as part of the key strategy to prevent any second wave or as we move out of lockdown, the government are very much focused on its test, trace and track strategy. And one of the central tools of that has been the development by NHSX of a tracking app. And NHSX is the digital arm of the NHS here. That app is actually still in a test or pilot phase in a specific part of the UK at the minute. I think it's fair to say we had expected it to be launched by now. And that has been delayed, and probably there's a couple of reasons for that delay, or why it seems to become a little bit less central to picking up on some of the themes I think we've talked about already, and I'll come on to in a little bit. But how the technology works is very similar to as Todd has outlined. Bluetooth technology doesn't collect location information, generates what's referred to as a sonar ID for each individual device. And whenever someone self-reports through the app that they're showing COVID symptoms, an algorithm runs in the background on the database to map that ID against other IDs that have spent a certain amount of time with them, what's called a proximity encounter. And that will also look at the strength of the Bluetooth signal at that point and send out notifications to those that are at risk. those individuals who receive those notifications will get a unique identifier to allow them to go for a test. There's also the intention to use some of this information collected for research and for public health management. I think it's fair to say one of the reasons that we have seen perhaps a bit of a delay and less focus on this being such a central tool is some of the privacy issues that have been discussed. We have had a detailed privacy impact assessment published for the NHS-X app. Interestingly, on that app, its own risk register only registered at a high green or amber issues, and that really focused on issues such as misuse of the app in order to get access to testing, or perhaps the risk of false positives. I think there's probably two other issues that have been more widely discussed in public around the use of the app. One is clearly around the information security risks that raise in any sort of approach like this. And indeed, the UK National Cybersecurity Centre is currently looking through a number of flaws that have been reported to it in the operation of the app. Although to an extent, that's not that unexpected, because the technical documents were published in order to get sort of crowdsourcing feedback. However, the other big issue I think that we've been talking quite a lot about is this issue that Nick has alluded to, the concept of centralised and decentralised models, and that alludes very much into what Todd was talking about as well. I'm sure lots on the call will have heard a lot of technical discussion about this, but at its most simple, what it breaks down to is whether whenever this matching exercise happens, does it happen in a big central database held centrally, or is it the exercise that sort of Todd was alluding to, where actually the individual IDs are downloaded on a periodic basis into the device and the matching happens there? Now, the NHS-X app has adopted a centralized model, so it's not using the Google Apple API, and that's come into for some criticism. Obviously, having a central database for those purposes does raise security risks. And there is some concern that's been raised around sort of governmental scope creep, ability to keep that large database anonymous. However, the benefit that's been trailed of using that centralized approach is the ability to do more modeling and really to understand the transmission of the virus across the population, and perhaps even identify, if you like, super infectors, those who seem to be causing the most duration of most infection. So, and there are some potential risks with the decentralized model as well. That periodic downloading of IDs onto a device is potentially a security risk itself. I think it's probably fair to say there's no clear-cut right answer in this. A lot of it, I think, will come down to issues around transparency. It's really interesting to hear, I think, what has been discussed in some of the other panelists around sort of the level of transparency we've seen and some of the rigor of scrutiny, oversight, and potential enforcements, and if there is further government use of the information. I think it is probably from a perspective to note that there have been press reports about a decentralized alternative is in process or is in progress with NHS-X in the event there is a political decision to flip to that model. Just two other quick points I think I'd make just in relation to where we are in the UK. I think the other thing that seems to be driving a bit of a slowdown in the app focus is this issue about take-up. I think Jianji's very eloquently made the points around the voluntary, and as has Chantal, around voluntary and non-voluntary. The app will be voluntary in the UK, and the number that's being floated in the UK is a need for 60% take-up. As a comparison, WhatsApp, the messaging app in the UK, has a take-up of about 65 to 70%, and that's hugely successful. I think we have seen examples in for example, Singapore, where the take-up is actually in the 20%, 25% market. So I think there is more of a transition currently to actually very interesting what Sahid was talking about, and that manual track and trace approach. And we've had a small army of about 20 to 25,000 people have been employed by the government recently to start to do that. Although interestingly, we haven't had any of the same sort of discussions around these privacy implications in large national databases being created for that manual track and trace that there has been around the app. One last very quick point I'll make. Passport certifications, health certifications, health immunity passports is an issue that is starting to come up a little bit in the UK. We had the Health Secretary just a few days ago talking about looking into the idea of an immunity certification, this idea that there's perhaps up to 4 million individuals in the UK that have contracted COVID and are now recovered, and whether they should be released from lockdown in a different way. But I think the science doesn't necessarily back that up completely yet. And there are some issues around potential discrimination, human rights, and maybe even automated decision making. But I'll pause there, and that's hopefully given an overview from the UK perspective.
Thanks, Simon. And yeah, I think from what I'm reading, the jury's still out on whether it's biologically or scientifically possible to have not just the antibodies, but the right antibodies to fight off the virus. And can you be reinfected? And it feels like we're just not far enough forward on that to know. Let's do another poll. So in relation to apps, and we're just curious, have you, very simple question, if we can have it on the screen. Yeah, have you downloaded a contact tracing app? Yes or no? So if you'd all like to vote on that. And then while you're voting, we're going to go to Robin Chatwood, who's definitely in Australia. I can tell that from her background, where it's very late. Robin,
Thank you. Yes, I wanted to discuss how Australia has approached the topic of apps. So the Australian government has developed in-house with the Department of Health its own app. It was based on the source code of the Singapore app because they were ahead of Australia on that. And it's interesting, when they released it, you know, they've since said that about 22 countries have contacted Australia for essentially being able to base their own app off the Australian app. It works very similarly to what Simon was describing in terms of it's a Bluetooth handshake. But they've had to pass specific legislation for the app to be regulated. And it's interesting, when they released it, at the same time the government gave a press conference on, you know, when would lockdown finish up. Australia's got a population of around 25 million. We've had 103 deaths as at today's date. So, you know, they've managed to handle the lockdown pretty well. About 7,000 people have been infected. And when they released the app, they basically said the release of the lockdown was directly correlated to how many people would download the app. And within 3 days, and then they associated it also with when they would allow pubs to open would be directly correlated with that. And when they would allow the football season to resume would be directly correlated with that. And so within 3 days, 3 million Australians downloaded the app. Clearly we like our beer and footy. And they did say at the time the target was around 40%. It's no real scientific basis for targeting about 40% of your population to have the app. And I've read elsewhere that, you know, 70% is probably the better indicator. But as of, you know, last week when I last looked, about 6 million Australians have downloaded it. So we're about the 44% mark. So it's been successful largely from that point of view. They also released a privacy impact assessment at the same time that they did that. Interestingly, the privacy commissioner here outsourced the privacy impact assessment to a law firm, which is an interesting way of going about it. And that law firm came up with about 19 recommendations, of which only one the government has endorsed publicly, around, you know, essentially making it easier and for the users to understand what's going on. The features of the legislation have been interesting. It's actually a criminal offence to force somebody at work to use the app. So that can't be enforced upon any employees. It's also a criminal offence to export the data outside Australia. And so it cost the government about $1.5 million to develop the app. And then they've actually had it hosted by Amazon Web Services, which has attracted some criticism. And it's going to be about $700,000 to host it. But the hosting requirement is that it will only be on a server in Sydney. Australia's adopted a centralised database approach. So, you know, after the Bluetooth handshake, and if you're within 1.5 metres of somebody for at least 15 minutes, then that data will get uploaded to the central database. And then when you self-elect to communicate with the app that you've tested positive, that's when there's going to be the exchange of data and an alert sort of system put in place. And so there's some interesting things in the privacy policy that got released with it, including, you know, in the fine print that they were going to use the data, you know, for other reasons, such as law enforcement, without any specifics on that, and also to prioritise, you know, who they would treat. And so the mind boggles about, do you prioritise the aged over prioritising the young? So no real information there. And it's obviously also come with attendant problems like, how do you really get consent from children and those sorts of people who might have smartphones. Doesn't really talk to the other legislation. There's also the risks of any app where you get the risk of false positive, you know, so it's falsely alerting you, even though you might have been 1.5 meters away from somebody, but they're on the other side of the wall. Or it could be false negatives where it's not detecting, say, coronaviruses on a surface. For example, it's only really communicating with, you know, 2 dumb phones, really. And so there's been some interesting aspects about that. You know, I guess the other thing I've seen is starting to see commentary in the papers about is around if you do have employees using the app at work or using it on the way to work, say on public transport, and they can actually identify where they've picked up or become infected. And so how much under, you know, employers' workers' compensation insurance, workplace health and safety laws, will the employer itself be liable because they haven't provided a safe workplace? And it can be detected and traced back to that you've got the virus at your place of work. So there's some interesting commentary and debate to come up about there. So I might just pause there. I think I'm, you know, at the
Sure.
my allocation.
Thanks, Robin. That's great. So let me, hopefully we can see the results of the poll. So the question was, have you downloaded the app? 90% no. Maybe a little bit predictable. We're not quite there yet. The interesting question actually would be to rerun that in 3 to 6 months and see where we've got to. But anyway, thank you everybody for participating in the polls. Now we've got a couple of questions, which I'm just going to throw one to Jianji in connection with open sourcing. Is there any consensus in relation to open sourcing of the apps, the contact tracing apps? Jianji, could you give us your thoughts on that one?
Yeah, sure. There is in fact consensus. And in fact, for instance, the Italian tracing app is based on open source codes, which have been published and now subject to comments. Likewise, what Simon was stating before, the point is making these apps as similar as possible and as interoperable as possible, because the issue is how to address also the movements that are not limited within the nation boundaries. So this is a point, and perhaps I may add another reference on this, which is related to the position taken by the Italian DPA on tracking apps, and it was adamant to say we should make as little tracing apps as possible. So once again, let's try and have 1/2 tracing apps, open sourced, but no more than that. And the tendency, and Nick, you were telling that before also in the previous webinar, is to have state-controlled apps. There's currently not a positive view. It could be considered a disproportionate reaction having private apps, but this is still a matter of a trend that is yet to be fully assessed.
Yes. Another question that we've had, Simon, I don't know if you'd like to deal with this one, is once you temperature check somebody and you decide whether or not to assume that determines they get into the building or not, that might, you know, if they're not allowed in, that might generate some email correspondence as to their COVID status. The question is, how, you know, can you record that? How long can you retain those records? Is there any clarity around on that if we do it from a UK perspective in this case?
Yeah, certainly. I know there's slightly different. It's interesting. We've done jobs with many of our panelists here for, you know, on cross jurisdictional matters, and I know there's definitely a variety, certainly within Europe, on this approach. But you know, from a UK perspective, I think you know, certainly taking that first step in terms of actually going into the border or into the building, can you actually undertake some temperature checking? I think that the general approach is there's flexibility within the law to apply that where it feels appropriate. I think the clear kind of indication we're getting at the minute is that should be, you know, an infrared thermometer or sort of, you know, real-time checking rather than a collection of that information or a database on that. And I think there's other European jurisdictions are sort of taking a similar approach. In terms of records that are then retained of that, whether it's email or central, I think, again, it really depends on the particular circumstances. I think you can kind of see where if it was a guest or someone from outside the building or outside the organization visiting when we get to maybe coming back to meetings, whatever those things are, you could see where there might not need to be any real record. It would just be a fact that the test has been undertaken without any of the underlying medical information. In respect of employees, you could see there needing to be potentially, if someone's been turned away from work as a result of a temperature check, you can see there being a need to retain some of that correspondence and information for a period of time. Particularly, and I think there's a really important play here with labour law aspects, and particularly as to how that individual will be treated. Will they be paid whenever they're not? Can they work from home or not? If that has an impact on the individual, then I think a justifiable period of retention would be appropriate. I think almost in the same way that I start to see it as a similar, if you get into a circumstance where you've got someone on long-term sick leave or there's some sort of labour issue like that, I think you can see some analogies there.
And also, I suppose, in defending your position that you took the appropriate action, because you mustn't forget there's a whole health and safety side to this. Just curious, so in, say, Colombia, Juanita, so if somebody tests positive on one of these temperature check, is temperature checked, is asked to go home, and there's some correspondence generated as a result of that, is there clarity as to how much how many records we can kind of keep on that, or are there limits on that in Colombia?
No, we don't have clarity yet. We know that we must follow the minimization standards. I mean, employers must keep the minimal standards of data, but whenever local authorities come to check, and they're mainly the police, they are not that informed, so there's a bit of a confusion there. I think that we will have more explanation afterwards. Yes.
And there's another question, a sort of related question we just got, which is, what should we do with email correspondence, destruction, etc., electronic shredding? I mean, yes, I think I think I can answer that, which is just, if something's to be destroyed, then absolutely it needs to be, electronic shredding, or however you want to describe it, but basically deletion. I mean, the issue, of course, another little challenge is it's unstructured data, right? So it's going to be hard to determine which bits. And we think this is one of the risks actually in this sector, that data is being held naturally in unstructured form, because it's not like we've had IT systems in place to cope with this. And so inevitably that's another challenge. So if I can kind of draw things together, just before we finish, it does seem that there are some common themes. One is that it's quite fragmented in terms of individual countries' responses, and particularly around the legals. So, particularly in Europe, can I temperature check? Can I make it mandatory? Answer yes for Lombardy in Italy, no for other parts of Italy. The CNIL, you're probably aware, in France have said no. The Labour Agency in France have said yes. Our experience is companies are ignoring the CNIL and doing it anyway, just to cut to the chase. And then there's a sort of a further debate that will need to happen around thermal cameras, where I think the risks are higher and it's more intrusive. And frankly, different approaches in different jurisdictions, state-based in the US, plus the Apple-Google API that Todd was talking about. The access to telco data in South Africa is very interesting, because the whole debate in Europe on that was heat maps, basically, generating information about volume of people in a particular area, not necessarily individuals being tracked. And the other thing I was going to mention was liability, which is this point about, you've got to look at the privacy aspect in the context of health and safety, because if we get it wrong, there's another consequence the other way around the block, which is that there could be claims, and claims will likely generate access requests, which is another component of data protection, data subject access requests. So I'm going to say we're almost at time. We're almost bang on time, actually. So thank you, everybody, for joining. We've had a lot of people join. We appreciate that. And thank you to all the panelists, Jianji, Chantal, Juanita, Shahid, Todd, Simon, and Robin. We managed to get everybody in with their allotted time, which is great. I hope you've enjoyed it. If you'd like to give us any feedback on anything else you'd like us to cover in these seminars, please do just get in touch with any of the team. And I will wish you a good and safe day. Thank you for joining.